Okay, the time.
4:11.
The time is now 4:11. I'd like to call to order the meeting of the Rules Committee. A copy of the agenda for this meeting may be found on the county website under the tab for the legislature. Please silence your cell phones and electronic devices. And at this time, I ask that you please rise for the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, thank you. Doreen, would you be kind enough to call the roll?
Amo, Fagion.
Here.
Feller.
Here.
Paduk.
Here.
Ramos.
Here.
Rosella.
Here.
Segenga.
Here.
Sutherland.
Here.
7 present, 1 absent.
Okay, great. So the first thing on the agenda, the only thing on the agenda, we have Alan Sorensen, our Commissioner of Planning Partner, Stacy, to approve SECRA short environmental assessment form and applications for the inclusion of lands into the Orange County Agricultural District number 1. May I have a motion and a second, please?
I'll make that motion.
Legislators Fagion and Segenga. It is my understanding that at the E&E meeting the other day that this was split and the Newburgh parcel was separated from
Yes, from
others
Walk Hill.
and from Walk Hill. Okay,
Okay.
so, okay, so I'd like to start that discussion.
Okay,
And,
just super quick, during the annual open enrollment for the Ag District, number 1, we received 2 applications, one from the town of Walk Hill, 36.2 acres for farm ag planting research. This is under New York State Department of Ag license number 36-10, and that property is at 345 O'Hare Road, Middletown, mailing address. The other property was 13.2 acres. The property includes 4 barns, 40 4 horses, and the proposal that was presented was that they wanted to expand to proposing to board 10 horses. When we received the when we submitted the initial legislative request, we included an environmental assessment form. One of the questions on the environmental assessment form asked whether or not we have received a written correspondence from a municipality in which the property is situated. When we submitted the initial environmental assessment form, we checked no on that because we had not received correspondence from the town. We subsequently did receive correspondence on May 29th of 2025 from the town of Newburgh opposing the inclusion of APJ Enterprises of Newburgh LLC into the Ag District. And in that correspondence, they cited a variety of enforcement actions on the property. With that, as was mentioned at the E&E committee, the action was split with a favorable recommendation on the Walk Hill application, but not on the Newburgh application.
Okay, so Betsy, I don't know, should we split this one as well, or can we leave it the way? I mean, because I would recommend splitting it as well, because, so I don't know if someone wants to make that motion, and then we can discuss them. Okay, so we have a motion to separate the 2 properties made by legislative I'm just having a hard time today, and legislator Paduk, I'm so sorry. It's been a long day already. So is there any discussion pertaining to that motion? Okay, all in favor?
Aye.
Anybody opposed? Okay, seeing none, we will split that, so the approval will start with the Walk Hill property, and we can do the approval for, we can discuss the approval for the Walk Hill property for the secret and the short assessment.
I'll make the motion.
Second.
Okay. Okay, Alan, do you want to explain the Walk Hill property and then we'll go on to the second one?
Yeah, so as I mentioned, the Walker property, it's 36.2 acres. The proposal is for farm ag planting and research involving hemp growing. And it does have a New York State Department of Ag license, number 36210. Ag and Farmland Protection Board went out, viewed the property, and the recommendation from the Ag and Farmland Protection Board is to include this property in Ag District number.
Okay, is there any questions or comments regarding the Walk Hill? All right, seeing none, I'll call the question. All in favor? Anybody opposed? All right, that one passes. And then we'll do the approval for the secret short environment assessment form and application for the inclusion of the Newburgh property into the Orange County Agricultural District number 1. Can I get a motion for that?
I'll make that motion.
Okay, Tom and Ron. Okay, I'll let you start the explanation on what happened on Monday.
Yes, so as I mentioned, when you received the initial packet, the environmental assessment form did not reflect the fact that we received a letter from the town of Newburgh because we hadn't received one. And in that correspondence from the town of Newburgh, there was a vote of the town board that was 5-0, indicating that the town of Newburgh is not in favor of including this property in the Ag District. They cited ongoing code enforcement actions and concern about including the property in the Ag District. One of the benefits of being included in the Ag District is it does afford the property owner some additional rights as it relates to nuisance complaints from adjacent neighbors. But in terms of like benefiting from like an ag assessment, a property owner does not need to be in an ag district for that purpose. There are numerous properties in Orange County that are not in the ag district, but that have submitted documentation to secure an ag property tax exemption. So, and I would add that we have an annual enrollment. So the enrollment period opens up March 1st of each year, runs through the entirety of the month of March. So if an applicant is not successful in one particular year, they can always reapply next year to be included in the ag district. The short environmental assessment form that is used for ag district enrollment specifically includes a question. I should read that question about whether or not. I just want to read that question. It asks specifically comments from municipalities within the county. Did the county legislative body receive any comments from municipalities about the addition or removal of land from the agricultural district? In the amended short EAF, we checked yes to that, provided a description of what that information is. I believe that question is on the form for a reason, and just to make sure that we have all the facts before the legislative body makes a decision.
Okay. Does anybody have any questions, or do you want, I know there were a couple of us who were on the committee on Monday that discussed this. One of the concerns was the right to farm, but whether we agree or not agree to this application at this point, they still have the right to farm. It doesn't affect any of that of what they're doing currently. There was also discussion as far as a timeline, and that we did understand that this would be able to be reapplied for in September once the conditions that were actually appealed to from the town of Newburgh.
March,
March, sorry, March.
of
I'm telling you, I
yes. March 26th.
Right.
The other timing issue is when the Ag and Farmland Protection Board made their recommendation, it was prior to this letter from the town of Newburgh, and the Ag and Farmland Protection Board meets tonight at 7. So I'm going to bring this letter back to their attention, so their recommendation may change coming out of that meeting.
And I also believe they didn't have we had the public hearing on, and we had that one person who
That's-
actually did speak, but wasn't privy to that testimony,
Correct.
wasn't privy as well.
Yeah, there was an
So-
adjacent property owner
Right.
proposed as well.
That did come up and speak as far as that. So, so any questions or comments or any, oh, go ahead, legislative session.
Thank you, Chair. As I said on Monday, we have before us, obviously, it's a letter from the town of Newburgh. We have the Ag Board's recommendation here. And included in the recommendation was a unanimous vote of the Ag Board to approve this property to go into the Ag District. That being said, as the Commissioner mentioned, the Ag Board's meeting tonight, obviously with some new information in front of them. My vote's going to be yes today to advance this. And if it does make it to the floor, depending upon the outcome of what is said tonight at the Ag Board meeting, I have every right in my vote to vote either yes or no on the floor. I'd hate for this to go down today, just because we have a letter from the town board and not a recommendation in difference from the Ag Board. So I'm going to vote yes today. And the intention is to take the recommendation of the Ag Board in conjunction with the town of Newburgh's letter and make my final decision on the floor.
Thank you.
Chairman wants to go first.
Chairman first?
Yeah, I'm gonna say the same thing.
I just want to point out that the town of Newburgh voted 5-0 with an opinion and a letter written to me on May 29th saying, please reject this for all the reasons. All of you got a copy of it. I'm sort of a home rule kind of person, and if the town wants to lead us in a certain direction, if it's legal, I think that's the way I would go with my vote on the floor if you decide to send it there.
Okay, thank you. And
So my comment is, actually, if it is not approved today, this committee now, it doesn't even make it to the floor. In my opinion, I believe.
that's correct. That would be correct. If it doesn't pass today, it will not be included on the agenda for
And
July.
that's my town board, and I will be supporting it.
Okay. Any other comments? Oh, legislative change.
Thank you. The additional rights, Alan, the additional rights that a property owner receives by being in the ag district are only for ag-related activities. So if they were doing something outside of ag-related activities, then they don't get any benefit from that, correct?
That's correct. I think in practice, it may make it more difficult for code enforcement. Just because it does, like if you're putting up a building, you're putting up I say a chicken coop or something like that, that's definitely an ag-related use. And so they're able to do that, not necessarily as of right, but with less stringent review. So I think that's kind of a subtle other benefit to being included in the ag district. But you're right, they still have to comply with zoning and all the local building codes.
So relative to the enforcement actions that the town is now taking or has against this property owner, are they ag-related from your understanding and review of the letter that was received from the town?
From the way they've described it, I would say it's beyond a typical ag activity. Because they talk about the storage of commercial dump trucks, trailers, construction equipment, backhoes. I grew up on a farm, we had some tractors and plows. Typical farm.
Hay balers.
Hay balers.
I'm gonna add something to that because that's one of my other jobs right now. A lot of these equipments could be considered farm equipment for using and moving, even though they're actually also considered construction vehicles and so forth, so that it's a very fine line. And with the letter that's being here, that there are open violations, as well as that the applicant had said he would correct them and has chosen not to. I think this could put the town in a predicament, and I think that with the home rule, I also agree that this could create an issue as far as that. So I will not be supporting it until I hear from the actual committee that it is something that they agree on now, because I think that a lot of this information may change the opinion of the group.
Just from the standpoint of how this then moves forward, what rights does the property owner, if this property isn't allowed to be, if a decision is made to not allow this to move forward by this legislature, what rights does or what actions could the applicant take relative to that refusal to move it forward? I mean, is there an Article 78 possibility? Is there, or are we kind of exempt from explaining why we said no? There are some ministerial activities.
We withdrew the zoning application, so we didn't exhaust administrative remedies. He's gonna have to go to the zoning board again, we did a denial of Article 78. I don't see how that.
And he also.
So I guess I'm kind of asking the attorneys and.
Well, then we'll let the attorney.
We have one over here.
We have a couple of them.
Mr. Mellon is an attorney as well.
No, I mean, because there's previous here, so.
So with the decision of the legislature, that is pursuant to, I believe it's 303 in the New York Ag and Markets Law. And so that decision rests within the purview of the legislature with the recommendation of the Ag Board. And in fact, once that approval or denial is afforded, the commissioner of the Ag and Markets in New York State is the one that actually makes the final decision as to whether a property can be included in the agricultural district. That being said, I certainly would ask Rick for his opinion on this as well, but I don't think an Article 78 proceeding would be the proper venue, would be the proper proceeding here in the event that they do not agree with our decision or try and override it. I think the real remedy here would be to reapply in March after whatever changes have been made. Historically, I don't believe that anybody who has been denied inclusion has ever brought any sort of proceedings, but has subsequently reapplied.
That's been the past practice. I don't think it's an inherent right to be included. That's why there's a review
Correct.
process.
And if it never gets to the commissioner, he can't force something in on an application from property owner.
I'd like to speak to what the commissioner.
Well, but I mean, if he can only deny something he receives. If we don't send him something, he can't say yes to something that he never received.
Okay, so does,
I
Go
would
ahead.
think that I would have to reread the process with respect to the commissioner to make a final determination as to whether or not they could do an Article 78. I think if it's something that we make a decision of a denial that never gets to the commissioner, I would think that that decision may be subject to an Article 78 as being arbitrary and capricious. I don't think it would be a matter of exhaustion of remedies, because that's just within the town that they have to exhaust their remedies for various purposes in order to challenge a decision that would otherwise be. This is something different than zoning. This is something dealing with ag and markets outside of the zoning context, even though the objection, as I understand, I haven't seen the letter, but as I understand what's being said, is that there are zoning issues that the town is raising. So I think that's possible. I don't necessarily think that should guide you one way or the other as to whether or not it's subject to an Article 78. Many decisions you make are subject to Article 78, and you don't necessarily decide not to do something for fear of an Article 78. One thing is that you may likely feel confident in your reasons, that you have substantial and valid reasons, and rational basis, which is what the standard is with respect to the arbitrary and capriciousness of what you're doing. And secondly, if it's wrong, there's no damages that are attached to that. The court would simply say, you have to consider them, or it was so arbitrary and capricious, they would have to say that you now have to recognize them. So it's, I don't think an Article 78 remedy really should decide how you go here. I would suggest, though, apropos to what the chairman had made, is that I understand the feelings of, thank you. You know, if a local municipality objects to something, but I think it depends upon each individual objection as to what it matters. I don't think that it's necessarily wise for the county to become sort of an adjunct enforcement arm for zoning decisions, and therefore to stop somebody from doing something else because they're having problems with it. So they have lots of remedies themselves, which I'm sure they're following up on to go ahead and bring them into compliance or force an action against them. But as far as the Article 78, it's possible there's an Article 78 if it would never get to the commissioner afterwards. So I think that could be considered to be a final action. But I don't think that that should guide you one way or the other as to how you determine this.
Excuse me, I just wanted to clarify, I did confirm with our clerk that although a property may not be recommended for inclusion pursuant to our resolution, the entirety of the applications and all the paperwork does get submitted to the commissioner. So the application itself, if there is one that is denied, does get forwarded, and they would have access to all the information that this legislature had.
Okay, so I think I have one question. If it doesn't pass in our county agricultural district, is it incorrect or correct that they can still go forward looking for the agricultural exemption on the, because there's two separate ones there.
They could seek an agricultural assessment as a farm operation, even though they're not in the district. So that is, they could pursue that, yes.
Okay, so this would not prevent them from going forward with that application and going that way, correct?
Correct. They would, they'd have to show that they're using it for farming purposes. They have income related to the farm operation. It's a pretty low threshold, actually, so.
What, $10,000 again?
Here.
I have a question.
Yes, please.
Can you clarify, so the town makes a note about concerns of the applicant attempting to use right to farm protections, but they still have the right to farm? Correct.
They do, but with, when you're included in an agricultural district, the typical case is the farmers operating a farm operation, spreading manure on the fields, and then they're getting nuisance complaints from neighbors. And being in the ag district would protect them from those nuisance.
No, it also include the tractors, the noise, if they're building something.
So it's
There's-
mainly around noise.
They get a little bit more leeway as far as.
Odors, dust, plowing fields.
But I don't think it's correct that stated here that necessarily shields them from improper agricultural activities and trying to hide them as agricultural activities. I don't think being in the district or not in the district really makes any difference in that.
Right.
Thank you.
And I just want to make it clear, I'm certainly not for including them. I'm just trying to clarify on a couple of small issues. It really doesn't matter.
Hey, legislative Purdue?
I would tend to go with the chairman. I do have a question though. So the board didn't have this letter when they made their approval.
That
And
is,
tonight, when they meet again, there's a possibility that the board goes with the town and says, okay, we're not gonna include them. We'll get that recommendation back before our meeting to vote on it, right?
yes.
So I would let it happen and, you know, the board's really making their recommendation to us. I agree with the chairman. I would think it would have quite an impact on the board itself if they hadn't had that previous, so. And the other thing is, when you go out there to look at it, do they look, you said there's farm vehicles and stuff, and do they have wheels on them? Are they in use or are they, you know, is it hard to tell? You don't get that deep into it.
Yeah.
I wasn't on this particular site visit, but 3 members of the Ag and Farmland Protection Board were, so they actually walked the property, and are able to see, you know, what's going on, so.
So they've seen a lot of the trailers or machinery or whatever there.
That, I want to clarify that with them this evening. It may be they weren't there when they went to the site visit, so I don't, because it was scheduled, so, yeah.
Okay, wait, legislator Cheney or?
I just wondered, what's the issue with tabling the motion for now? Tabling the vote, is there a deadline?
There is a
There was a
deadline.
deadline.
The Ag and Markets Law requires a decision to be made within 120 days of the closing of the notice period, which was March 31st. So that 120 days is up on July 29th. So once it passes committee, it has to pass the full legislature on or before July 29th.
June 29th?
No, July 29th, so it wouldn't make the August meeting, so.
Oh,
And just for this committee's edification, there is actually case law in Putnam County with an Article 78 that was filed with the court following a failure of the legislature to include a property. The court in that ruling issued it arbitrary and capricious, and it was remanded back to the legislature in that instance for further review.
Thank you.
Yes. Legislator Cheney.
Commissioner, when the Ag and Farmland Protection Board does one of these reviews, what are the criteria that it focuses on to determine whether it's fitting to include it in the district?
One of the main things they look at is whether it's viable, purchase viable agricultural lands that it can use for a viable agricultural purpose. So I'm certain that they will deliberate this at great length tonight and
But they've already determined that it's viable. From their point of view, they
Yes.
made an inspection, they've looked at soil maps, I'm sure.
Yeah.
And they feel that it's viable, which is what they're tasked with doing.
yeah,
I guess I wonder whether they could turn around on that just based on the letter from the town. I guess they can do anything they want.
well, they may not. You know, they're pretty thorough, but they very well, you know, may change that decision based on this correspondence.
Thank you.
So that would actually let them get away with the violations that they haven't, or haven't.
And no, as Rick mentioned,
I mean, it'd be in the ag district, so they wouldn't, they could physically say like they have now, well, we haven't done them and we got in, so we'll get to them when we get to them.
it's not, no, it's not that. I think there are some people that want to get in the ag district think, you know, if they're in, then they can do whatever they want, but they still have to comply with code enforcement. It's probably easier to put up a farm stand, you know, as an example. But like if you're putting up a barn or sheds, you know, it still has to meet the code enforcement.
And it certainly wouldn't have any retroactive effect. So if there were code violations prior to that, even if
They're
the
still.
designation would change that somewhat, they're still just as responsible for those things that happened prior to any designation.
Okay, any other discussion?
I just believe in home rule. I also believe that if you have violations, then you're given the opportunity to reapply in a timely manner next March, that fix the violations and reapply.
Okay, and they could reapply in March,
Mhm.
so
Yes.
it doesn't really change anything, because they still have, I mean, they I believe have the horses on the property right now. Maybe,
Yeah, 4.
okay, nothing else? All right, we'll call the question, all in favor of the approval.
Aye.
How about roll call?
Oh, we're gonna have to do a roll call, I'm sorry. Please, Doreen.
Nope, no problem. Fagion,
Yes.
Feller,
No,
Paduk,
No.
Ramos,
No.
Ravella,
No,
Stiganga.
No.
1A, 5 no's, motion fails.
So they don't go anywhere now, so you don't present that to the board tonight?
No, I have it on the agenda already, so I think it's important.
Yeah.
You just tell them what happened.
Still discuss it.
Yeah.
Okay, and with that, that's the end of this meeting, so I think.
Nope, we got
we
to
lost- oh, wait.
kill one.
We already.
No,
We did the walkout, I did the walkout
Yeah,
first.
first.
Yep, I did that first. So, motion to adjourn,
Second.
okay.
Thank you.
nothing to do with the.
Oh, thank you. Thank you so much.
We used to have a portable air conditioner.
Yeah.